since we have a packed schedule. And as a start, while we do introductions, we encourage you to introduce yourself in the chat with your name, organization, and your role. Today is our first AdaptLA meeting of 2023. Welcome everyone, and thank you for being here. We had a huge number of registrants, so we're really excited to have such interest in this first meeting. Today's topic, as you all know, is the legal dimensions of coastal adaptation planning, and we have a really special guest speaker who's going to be sharing her research in this field. My name is Karina Alvarez. I'm a science research and policy specialist at USC Sea Grant. And as part of my role, I coordinate the AdaptLA program, which is bringing you this meeting today. Thank you again for being here this morning. Before we get started, we'll just acknowledge the area in which we work. While today's webinar will be having a lot of applicable lessons throughout the state, USC Sea Grant's work primarily focuses in Southern California. And so we want to acknowledge the history of that land. The Southern California Bight is located on the unceded, sacred, and traditional lands of the Tongva, Ahashiman, and Chumash nations, the first native peoples. They are the original stewards of this land, and they continue in this role today. So just a little bit about what we can expect today. We have a pretty straightforward agenda, as you saw when you registered. Again, we'll be learning about the legal dimensions of adaptation planning, land use, managed retreat. And we'll just be doing a few minutes of introductions and kind of housekeeping for the first few minutes, and then we'll dive into a presentation by Dr. Robin Craig. And then we have some space for Q&A at the end of the session. During the first 45 minutes, we ask that you ensure that you mute yourself so that we can reduce interruptions during the presentation. So before we get started, the one big introduction we wanted to do is to the AdaptLA program. We noticed in the registration that for many of you, this is your first AdaptLA meeting. And so for all of those people, welcome. For those of you who have been involved in AdaptLA for a while now, welcome to you too. We're really excited to have such a mix here today. So just a little bit about the AdaptLA program. It was started over 10 years ago, and it has the goal of supporting planning for the coastal impacts of climate change and building climate resilience into communities. The way that AdaptLA does that is by linking coastal jurisdictions with the best available science so that can then inform planning efforts. Now, in being that kind of convening role, we develop a community of practice in the LA region, not only between coastal jurisdictions and scientists, but also between coastal jurisdictions and community-based organizations, all with the goal that we're able to share knowledge, best practices, and kind of learn from each other. All that is to say is, although we have these scheduled meetings at a certain frequency, that's by no means limiting when we can have these conversations. So we really encourage you to keep in touch, reach out. We're here to be helpful. And so we're happy to be able to connect with you in whatever way that is. And I'll have some resources at the end for those of you that want to stay connected on how to do that. So we want to jump right in because we are so excited about our guest speaker today, Dr. Robin Craig. So I'll just introduce Robin and then I'll pass it over. So Dr. Robin Kundis Craig is the Robert C. Packard Trustee Chair in Law at the USC Gould School of Law, where she teaches environmental law, water law, ocean and coastal law, toxic torts, civil procedure, and administrative law. Craig specializes in all things water, including climate change adaptation in the water sector, the food-water-energy nexus, water quality and water allocation law, marine protected areas and marine spatial planning, and the intersection of freshwater and ocean and coastal law. Craig received her BA from Pomona College in Claremont, California, her MA in writing about science from the Johns Hopkins University, and her PhD in English literature, specializing in how the English Romantic poets used contemporary science to explain social change. So cool. From the University of California, Santa Barbara. And received her JD summa cum laude with a certificate in environmental law from the Lewis and Clark School of Law. Dr. Robin Craig, thank you so much for being here today. We're really excited to hear from you. And with that, I will pass over the screen sharing privileges to you.
Well, thank you, Karina. It's very nice to be here and delighted that so many people were interested. With the caveat being we weren't quite sure who was going to be here. So this is going to be kind of a high-level overview, focusing on some issues I thought a lot of people might be interested in. And so what is that overview going to be? Just a little bit on sea level rise and projections for Southern California. A little bit on how coastal communities might respond to that sea level rise. But then getting into some of the law, who are important regulators and what are some of the unanswered legal questions for coastal adaptation. And then finally, what everybody finds fascinating, but legally doesn't change a whole lot, takings litigation, every local government's fear when they get into coastal adaptation. So looking at sea level rise and projections in general and for Southern California, we now have the Intergovernmental Panel on Climate Change's sixth assessment report coming out in stages. The final synthesis report will come out next month. And it has updated its projections for sea level rise. So here's its global map for sea level rise going through 2100. And also it's kind of projections about when we might see various levels of sea level rise as a global average. And I want to emphasize that because, as probably all of you know, and as the map on the left indicates, how various places experience sea level rise can be a very local phenomenon. So some places are already experiencing higher than normal sea level rise. Some places, you see that very dark spot in the Gulf of Mexico for the United States, where the land is subsiding, or are also having the combined effects of sea level rise plus that land subsidence. And the Arctic is experiencing higher than normal level or higher than average levels of sea level rise. It also, of course, depends on what we do to mitigate climate change in the meantime. And that's why these projections on the right are interesting. The dark red is the business as usual scenarios. The light blue is we get our act together very quickly and reduce greenhouse gas emissions very quickly. Obviously, that starts to make a difference, but the error bars get wider and wider as we go farther in the future, regardless of the scenario. So possibly looking at 2 meters global sea level rise on average, again, with local variations. Couple centuries out, but even a meter, 3 feet can make a big difference depending on where you live. All right, so California is very much part of that local variation in what's going on the coast. And this is NASA Earth Observatory's map of parts of the California coast that are sinking and parts that are rising. And so what you get on average is that global sea level has been rising at a rate of about 0.1 inches of 3.3 millimeters per year for the past 3 decades. That rise is occurring because of thermal expansion of warming ocean water and the addition of fresh water from melting ice sheets and glaciers. But the elevation of land, like I said, is also changing relative to the sea, which means in California in particular, we're going to have some very interesting local variations in how sea level rise is impacting the coast. You can see some very dark blue areas where the land is subsiding. You can see some red areas where parts of California are actually uplifting, and that includes Los Angeles. So, like I said, we're going to have a lot of local variations in California about what sea level rise actually means. Los Angeles County, borrowing some graphics from Climate Central. What is our best case by 2030? Some flooding along the beaches, Seal Beach, Terminal Island, Long Beach, feeling the brunt of it, Newport Beach. Worst case by 2030, again, taking these projections at their worst. Again, same areas are getting hit, but even harder. And then by 2100, worst case, could be pretty inundative for many parts of the Southern California, LA County area. So, coastal responses. What do local governments think about in responding to this sea level rise? Three basic categories of responses: protect, accommodate, and retreat. This actually comes from Ventura County's planning. Protect is just to put some sort of barrier in between development and the ocean. Accommodate is things like putting houses on stilts or building coastal designs, building designs that can withstand storm surge and sea level rise a little better. And then, of course, retreat is what a lot of communities view as the last resort, but actually physically moving away from the ocean to allow the ocean to migrate in and hopefully develop new coastal ecosystems. More complex view comes from the Natural Resources Defense Council. One response is to do nothing, and there are a number of coastal communities around the United States that are de facto following this response, which means eventually you will have inundation of houses and industries along the coast. There are a lot of contaminated areas around the country in the coastal zone, and sea water and hazardous substances is not a good mixture, as Hurricane Katrina and Superstorm Sandy both taught us. So doing nothing is probably not a long-term great response for anyone. Again, you have the protect option, the accommodate option. There are some communities experiencing coastal growth, even as sea level rise gets worse. And then again, at the bottom, the retreat, but the Natural Resources Defense Council also notes the option of retreating with ecosystem-based adaptation, meaning you're actively trying to promote the replacement coastal ecosystems as you pull back human development. All right, so protection, various ways to do protection. It runs green to gray, and I'll show that in a second, but you can build up dunes, for example, in front of coastal properties, trying to engage in some form of beach renourishment. Beach renourishment has a poor long-term track record. If the sand got removed once, it will probably get removed again. But as a interim measure, it can work very well in some locations for at least a short period of time. And I will end with one example of that. Armoring is a more common response, but has long-term detrimental impacts to the beach in most circumstances. But you can have revetments, you can have armoring, you can have seawalls, you can have groins, all sorts of different structures that can be put in along the coast, trying to hold back the sea. Eventually, the sea will win. That is the one great truth about coastal armoring. And usually, as I said, you're eating away what beach remains with armoring as well. So an example in California, this is coastal armoring along the coast in Malibu. That big pile of rocks in front of those very expensive homes. You can also see that the tide is coming right up to those rocks. So very little dry sand beach left, and that is fairly typical when local governments engage in coastal armoring. All right, again, there's green and gray approaches to this protection option. various governments, various local governments around the country are experimenting with vegetation, with putting in edges with vegetation, different arrangements, trying to avoid doing the full-on gray or hardening of the coast. Some places have been very successful. Connecticut has had some very successful projects putting in this green infrastructure to slow down storm surge and allow the coast to evolve into productive ecosystems. But it is still not the dominant approach around the United States by any stretch of the imagination. All right, and there are different techniques you can use over time. So again, this is going back to Ventura County. One common planning strategy for local communities who are looking ahead is to think about what are going to be the signals that different kinds of adaptation are necessary. So when storm waves start overtopping the beaches, maybe you start thinking about a different coastal adaptation strategy than just bear with it. Flood insurance, or when the flood insurance claims start being necessary, or when private insurers leave an area, is a pretty good sign that maybe you need another adaptation strategy, that it's getting bad enough that insurance or lack thereof is becoming a factor in whether you can live on the beach. And you know, loss of beach, actual inundation obviously can trigger another level of adaptation. So the point here is local communities can stage adaptation strategies along the coast. But it's good to agree in advance of what the trigger is going to be to move to the next stage. It is much easier to make those decisions calmly before they happen than not so calmly as places are being inundated. All right, so that's the overview of what kinds of strategies we are looking at, or coastal communities are looking at. I'm going to start, as I said, with an overview, and this is very much an overview of some of the regulators who are important to these adaptation decisions. And then, like I said, look at a takings law and how that might or might not play into this discussion. So in the regulators in California, we have, of course, the California Coastal Commission. It was created in the 1976 Coastal Act, which provided for a comprehensive scheme to govern land use planning in California's coastal zone. The commission is the state coastal zone management and planning agency for the Federal Coastal Zone Management Act, and that includes consistency determinations for any federal project, meaning either a project carried out by the federal government or a project licensed or permitted by the federal government that could affect California's coastal zone. Right now, that authority might become interesting because of federal plans to engage in wind farms and possibly aquaculture in the federal waters off of California's coast. In the past, it has been very important for oil and gas development off of California's coast. So that authority is likely to be increasingly important in the future. What is California's coastal zone? That's defined by the Act in Section 30103. It's the land and water area of the state of California from the Oregon border to the border of the Republic of Mexico, specified in maps that the state legislature adopts, extending seaward to the state's outer limit of jurisdiction, including all offshore islands, and extending inland, generally 1,000 yards from the mean high line of the sea. So what does all that mean? It's the entire California coast. It goes out to California's ocean jurisdiction, the limits of California's ocean jurisdiction under the Federal Submerged Lands Act, which is 3 nautical miles off of shore, and includes all those islands. Inland gets a little more interesting. The default is 1,000 yards from the mean high tide line going inland. But as the act provides in significant estuarine habitat and recreation areas, that coastal zone goes much farther inland to the first major ridge line, or 5 miles from the mean high tide line. So quite an increase in the inland part of the coastal zone. On the other hand, in urban coastal areas where there's a lot of development, it may extend inland less than 1,000 yards. And finally, the coastal zone does not include the area of jurisdiction of the San Francisco Bay Conservation and Development Commission. It has its own comprehensive planning authority. So graphically, this is what California's coastal zone looks like. The land areas are all those areas in red, plus 3 miles out to sea, 3 nautical miles out to sea is California's coastal zone. Plus, as you see near the bottom, all of the Channel Islands are included. All right, what's the commission's jurisdiction? It has jurisdiction to review any permit action, which I'll talk about in a second. It has the jurisdiction to develop categorical or other exclusion from coastal development permit requirements. As I've already mentioned, it engages in that federal consistency review for federal projects or federally licensed or permitted projects. It has oversight of local coastal problems. So the goal of the Coastal Act is to have local governments reflecting those local variations in what might be necessary, take over a lot of the coastal zone management and planning. So any government entity with beachfront property within its borders must adopt a local coastal program. And those adoptions and changes are subject to the California Environmental Quality Act. So a lot going on just in those local coastal programs legally. And the California Coastal Commission has oversight of most coastal development plans, including port master plans. So a lot of oversight authority, but also a lot of devolution to local jurisdictions to meet their own local conditions. Coastal development permits are really the main regulatory part of the program. So any person wishing to perform or undertake any development in the coastal zone must obtain a coastal development permit. These usually come from the local governments first, but as I said, with review by the commission. It's a very broad definition of development, and that could be interesting as we get into coastal adaptation to sea level rise. But under section 30106, development includes the placement or erection of any structure on land, in water, or underwater, the disposal of any dredged or material or waste, the grading, removing, dredging, mining, or extraction of any materials, a change in density or intensity of use of the land, or changes to coastal access. And if you're familiar with the Martins Beach litigation, one of the points made clear in that litigation was that blocking access to the coast requires a coastal development permit. All right, when it comes to shoreline armoring, that too is part of the Coastal Act, which tries to limit when coastal armoring can be used. It provides that revetments, breakwaters, groins, harbor channels, seawalls, cliff retaining walls, and other construction that alters natural shoreline processes shall be permitted when required to serve coastal dependent uses, or to protect existing structures or public beaches, and when designed to eliminate or mitigate adverse impacts on local shoreline sand supply. This list is meant to be a limit. These are the only times when that coastal armoring is required. The California Coastal Commission has been in litigation with several landowners across the California coast about when exactly you are an existing structure or when you have ceased to be an existing structure because you're redeveloping, rebuilding. A very heavily litigated part of the Coastal Act. All right, so that's what, like I said, a whirlwind overview, and looking at some of the issues from a lawyer's point of view going forward for coastal adaptation. In general, how will the California Coastal Commission deal with changing coastlines and ecosystems? It's got some guidance being developed. It issued some guidance in 2015. It's got some guidance still being developed on trying to help local communities as much as possible adapt to climate change and sea level rise, and I'll get to that in a second. But all of that is subject to legal review, and so remains an open question how the California courts will react to the California Coastal Commission's support of local governments and local coastal programs trying to deal with some of these issues. So for example, I mentioned that any change in density of housing in the coast under the Coastal Act requires a coastal development permit. Well, does that include if you're retreating? Does it include decreases in density as well? There are ways the California Coastal Commission can deal with that through exclusions, but there are questions left to be answered. There are also some good reasons why a permit requirement might make some sense, because what we don't want is a whole bunch of abandoned buildings left on the coast to be ravaged by storms and sea level rise. That's not good for anyone. It does not leave a productive coast behind. And as I said, you're probably dealing with some hazardous substances as well. So it may make sense in some instances, even in a retreat situation, to have some permitting requirements and have some requirements about how that retreat occurs. And then how will the Coastal Act dovetail with more general police power authorities to deal with nuisance, dangerous structures, and other public health and safety threats? There is inherent power in both state and local governments to deal with things that are dangerous to public health, welfare, and safety. And as we get storm surges, as we get buildings that need to be condemned, some of that authority may come into play in dealing with the immediate impacts of storm surges and coastal development. But as I said, the California Coastal Commission has some very good guidance out there. This is interpretive guidance, not regulations, but the commission has made it a high priority to support local coastal plan updates that are addressing climate change, and that includes hazard avoidance, protection of those coastal resources, and any innovative designs and coastal adaptation strategies that make sense for what that locality is experiencing. And that guidance does emphasize the local differences in coastal development along the coast. So evolving field of law, but with a supportive coastal commission and some legal questions yet to be answered about for how long hardening the coast will be allowed, and how creative local governments can get in their coastal adaptation plans without triggering lawsuits or judicial intervention. So we'll all see. It's an exciting and interesting time to be into coastal law in California. The other regulator I wanted to just mention, because of the Army Corps of Engineers gets involved in any coastal adaptation project, that can trigger a lot of other review procedures that have to go on. So there are two authorities of the Army Corps that are potentially relevant under the Rivers and Harbors Act of 1899. The Army Corps plays a prominent role in permitting any structure you place in the navigable waters, particularly the ocean. And under the Federal Clean Water Act, the Army Corps permits discharges of dredged or filled materials into waters of the United States, including coastal wetlands. Many of you are probably well aware that what constitutes a water of the United States has been a legal mess for a couple of decades now. We have a case in front of the Supreme Court as I speak that may or may not add clarity to this. Why I'm not particularly worried about that here is the ocean is very definitely federal, very definitely a navigable waterway. And there has never really been a question about the true coastal wetlands that connect directly to the ocean. So I don't think anything that's going on under the Clean Water Act with respect to waters of the United States is going to dramatically affect or even affect at all the Army Corps' authority along the coast. The Army Corps also issues lots of general permits under both statutes that cover a lot of minor and basic coastal interventions. So it is quite likely that smaller activities can be easily covered with a general permit. They're both nationwide general permits and regional general permits, with the one caveat that these have to go through California's certification under the Clean Water Act. And California tends to put more conditions on these general permits than other coastal states. So there are some California specific conditions on those permits that you wouldn't see other places. And unlike the California Coastal Commission, which is a state agency, the Army Corps' involvement can trigger a lot of reviews under a host of other federal statutes, including the National Environmental Policy Act, or NEPA, and the Federal Endangered Species Act. You might have historic preservation issues, you might have heritage issues, you might have tribal issues, depending on where exactly the project is issued. But like I said, once you get the Army Corps involved, you're going to trigger a whole lot of other review under federal statutes as well. All right, so takings. It's hard to talk about doing anything in the coast, particularly changing large uses of property, without talking about the private property owner's perspective on it, which ends you up in takings litigation. Now, I want to stress from the beginning that governments usually win takings cases. A lot of cases get filed, but governments usually win them. That doesn't mean they're not expensive, and it doesn't mean that governments are wary of them. But governments do usually win. So takings most generally comes from the Fifth Amendment of the US Constitution, which says that no person shall have their private property be taken for public use without compensation. So governments can take private property for public use. Public use is defined so broadly as to not be much of a restriction. But they have to pay for it. And so takings litigation is an assertion that a government has done something that affects private property to the point where the private property owner needs to be compensated. So that involves knowing what private property rights are on the beach. There are some special property rights that go with beachfront ownership. Private beachfront owners have the right to have the water remain in place, meaning they have the right to keep connection to the water. They have a right of access, which includes contact with the ocean, the right to accretion. So if the beach is actively building up, that becomes part of private property down to the mean high tide line. They usually have a right to purchase the submerged lands in front of them if the state decides to sell them. That's unusual in California. There's a constitutional prohibition on it, but it can happen. And when it does, the owner right in front usually has the right of first refusal. And if filling is allowed, again, unusual in California for that to be allowed, that owner usually has the right to first dibs, if you want it, to do the filling. There's a right to wharf out, which is the right to build a dock or a pier, subject to reasonable state restrictions, and a right to use the water. So there are some special rights that go with beachfront ownership that more inland private property owners do not have. All right, so takings claims, a brief history, what I call the good old days of takings claims. It was only physical takings of your property. If the government bought your property for a government office building or to build a highway, fine, that's a taking. They have to compensate you. They usually knew that. They used eminent domain with the intent of paying you from the beginning. But on the flip side, the court said that no proper exercise of the police power can support a takings claim. So if you're acting to protect public health, safety, welfare, if you're engaging in normal environmental regulation, that was a complete defense to any takings assertion, regardless of what you did to private property owners. So Mugler versus Kansas in 1887 was a famous case. State statute outlawing alcohol was fine, even though it put the brewery out of business. So the fact that the state law had put the brewery out of business did not support a takings claim. Hadachek versus Sebastian here in Los Angeles in 1915. There was a Los Angeles ordinance that said you couldn't manufacture bricks within the city on air pollution grounds. Gives you some idea of how long Los Angeles has been dealing with air pollution problems. It basically put a brickyard out of business, reduced it to less than 10% of its former value. And the Supreme Court, US Supreme Court said, no, that's not a taking. Los Angeles is regulating to protect public health and welfare. You're fine. The map on the left is one of my favorite examples of a potential physical taking. One of the many border fences that was being contemplated at one point would have put part of the University of Texas, Brownsville in Mexico, and the University of Texas rightly protested that that would be a gift to Mexico and a taking of its university. So, but where regulatory takings came in, which is where the law gets complicated, was in Pennsylvania Coal versus Mahon in 1922, involving coal mining. Part of the issue was that the coal rights were separate from the surface rights. And so Pennsylvania had put in requirements that coal miners leave enough support in place so that the surface did not collapse, which struck most everybody as a completely reasonable regulation, except that in Pennsylvania Coal's case for one parcel, those structural support requirements meant it could not mine at all. And it brought the case before the Pennsylvania courts and then the US Supreme Court. And the US Supreme Court said, yeah, if a regulation goes too far, if it impedes your property right too much, that can be a taking. That was all the guidance we got from Pennsylvania Coal versus Mahon. It's kind of a we know it when we see it sort of decision, but a regulation could go too far and cause a taking, even if it had a clear public police power purpose. So we got the test for regulatory takings out of the Penn Central case. The company that owned Penn Central Station in New York wanted to develop it. The development plans were pretty much considered hideous by all concerned. But the city of New York said, no, it's a historical landmark. We'll give you development rights somewhere else where you wouldn't normally have them, but you can't put this monstrosity of an office building on top of the historic Penn Central Station. And the court said, yeah, okay, City of New York, that works for us. There is a potential regulatory taking, but that's okay. The three-part test we're going to look at is the economic impact of the regulation on the claimant, the extent to which the regulation has interfered with legitimate investment-backed expectations, and the character of the government action. And in the Penn Central case, the court said, hey, you're protecting a historic landmark. You gave them development rights somewhere else, so they're not really losing out economically. That's fine. Governments win 99 point something % of regulatory takings cases. Physical takings, the Loretto case just made the case that any physical taking requires compensation. This case involved a requirement that apartment building owners allow cable companies to string cables for cable TV. I defy you to find the cable in the picture of the building whose owner brought the lawsuit. But nevertheless, the court said, yeah, that's a physical taking. Any physical taking requires compensation. Pay them for forcing them to lend part of their building to the cable TV operators. And then on the coast, very famous case, Lucas versus South Carolina Coastal Council. David Lucas had two buildings on the South Carolina coast, or two lots on the South Carolina coast that he wanted to develop. The South Carolina Coastal Council said no, because it was well aware that Lucas's lots could regularly be underwater. So a very clear concern. The US Supreme Court said, well, if you take all economic viable use of those lots, it's a taking, unless it was part of the background principles of his property rights that he couldn't develop at all. Net result was Lucas couldn't develop. Eventually, South Carolina got to assert its ordinance, but it took a trip to the Supreme Court to be able to do it. So background principles in California, we've got nuisance, we've got the doctrine of public necessity, we've got the California Public Trust Doctrine, which is pretty strong, and we've got public prescriptive easements for access in California, all of which can limit takings claims. All right, just to go through that really quickly, I know I'm running out of time, but we have physical takings, always require compensation. We have regulatory takings, that Penn Central balancing test. The government wins most of those. And we have the Lucas per se takings, a regulation that destroys all economic use requires compensation. In the Lucas case, that was conceded at trial. No one ever concedes it anymore. So a coastal property losing all economic value is unlikely. Last one I want to mention is Nolan versus California Coastal Commission, which introduced the exactions takings concept. Nolan had a small beachfront home in California, regularly referred to as a shack in the litigation. He wanted to upgrade. California Coastal Commission said, yeah, you can have your coastal development permit, but you have to grant the public an easement to cross the Nolan's lot to get to the public beach. The US Supreme Court said that exaction, that condition on the permit, was unconstitutional because there was no nexus between the problem the Coastal Commission had identified, which was loss of view of the beach, and the condition it actually imposed, which was access rights. California Coastal Commission has not made that mistake again. When it's worried about access, it says it's worried about access. And like I said, that's called an exaction taking. All right, absolute last thing I want to discuss in the takings context is the positive case for coastal adaptation. Came out of New Jersey, Borough of Hardy-Cedars versus Karen. The Borough of Hardy-Cedars, as you can see, is kind of out there in the Atlantic Ocean. It built up the dunes in front of a lot of property owners' property. The Karens were the only ones who really objected to this city doing that. And they brought a takings claim claiming that the city had taken their right of view. Immaculately timed case. So this is the actual house. The dunes are no longer there because of Superstorm Sandy. So trial court, they were awarded takings compensation for their loss of view, about $375,000. Superstorm Sandy hit the Karen's house, and the houses all along that stretch that had the dunes were protected. They were still standing after Hurricane Sandy. Neighborhoods next to them where there was no dune, no protection, mostly flattened during Superstorm Sandy. So that happened during the appeal, went up to the New Jersey Supreme Court. New Jersey Supreme Court said, you know, in that takings compensation, you've got to count the value that the dunes added to the property, as well as the decrease in value from the loss of view. The Karens had an initial award of $375,000. The city had initially offered them $300 to allow the city to put in the dunes. When all was said and done, the Karens got $1. When you counted the benefits from putting the dunes in for coastal protection, their land was worth way more, particularly after Superstorm Sandy, and everyone could see the benefit. Then the loss of view impeded the value. So, like I said, it's a very positive case. It didn't occur in California, but it's a way of looking at coastal adaptation and those protective measures. So I will say thank you and look forward to questions. And hope that was an overview that everyone enjoyed.
Thank you so much, Robin. That was excellent. I think giving us the framework and kind of the foundation to be able to talk about these things is really beneficial. So I'll open it up now to questions. I see that we have one in the chat. I encourage you all to, we're a manageable size group, so we'll keep it in this discussion format. But I encourage you to either raise your hand or throw your question in the chat. So I'll send the first one to you, Robin. We have a question from Dr. Tom Williams asking if there's any jurisdiction or countermeasures regarding oil production from shore and offshore fields and injection, and for compensation for past bottomland subsidence or sea level rise.
Okay, if I am interpreting that question correctly, are we asking about oil and gas production that has caused subsidence? Or okay, Dr. Williams is here. He can flesh out the question for me.
Yeah, feel free to come off mute, Dr. Williams.
Hi. Yeah. In the ports of Long Beach and Los Angeles, there's a lot of underground, underwater oil production. Has been for a long time. In some places, there was 30 feet of subsidence due to non-injection of balancing fluids. That has changed. And one of the issues would be if there is a measure to raise the bottom of parts of the port by injecting fluids into the subsurface, would that be allowed, or would it even come under the jurisdiction of the Coastal Commission or the state of California, other than for the injection program for oil production? CalGEM has the permit issues for the injection, but since it is subsurface property, there's usually no surface rights involved. But if we could raise the ports of Long Beach and LA, would that require a coastal permit?
That would be an interesting question, and I'm going to give you a typical lawyer's answer of it's going to depend on exactly how it's done. Because if you can do all that without affecting the land surface or the water, it might not be within the Coastal Commission's jurisdiction. But if it's an artificial change to the coastline itself, I can see an interpretation that would put it into the Coastal Commission's jurisdiction. And certainly if you had to do anything else that affected the land surface or the water, that would put it under the Coastal Commission's jurisdiction. So it would be fact dependent, as many of these jurisdictional cases are. I can see the argument for being jurisdictional regardless, but that's one of the many things that will have to be ironed out by the California courts in terms of whether it's jurisdictional or not, and under what conditions is it jurisdictional. So sorry for the wimpy lawyer answer, but it's right on the edge of what would be included and what we're not. And I would need more details to be able to give you a decent answer.
But there were some issues in one of your maps that showed either rising or depressing of the land as part of the coastal zone in one of your maps. And you might say some of those depressions actually correspond to oil production and or the oil industry's re-injection in order to raise the bottom level.
Yeah, I didn't say all of them were natural. I just said the coasts are doing different things at different points. So
yes.
Yeah, but like I said, how much of that artificial change falls under the Coastal Commission's jurisdiction is going to depend on exactly what's going on where.
Thank you.
Okay.
Thank you for the question, Dr. Williams. We have another question in the chat from Gabe Seidman asking, have there been any cases or talk of cases about wind farms taking away value from coastal properties by hurting the view? Gabe mentions that there has been some pushback against wind farm development for these reasons.
Yeah, there actually has. And we finally got our first wind farm off the coast of Rhode Island, the Block Island Wind Farm. But that was not the first attempted. The first big attempt was off of Martha's Vineyard, which you would assume would approve of wind farm development, but the coastal owners there did not want to be looking at wind turbines. The irony was the wind farm was actually going to be in the federal waters off the coast of Massachusetts, but you could see the turbines from the coastal owner's view. And of course, to get the electricity back to shore, you have to run a cable back to shore, which means you're crossing state-owned submerged lands, which meant the state had the right to get involved. It never became a legal takings case, but the political dynamics of all of that eventually resulted in the wind farm not getting built. So yes, that very much did come up, and it has come up several times from coastal communities that you would think would be liberal and in favor of alternative energy sources until it's right there in their backyard, and they raise in the permitting processes all sorts of not in my backyard objections to the wind farms. Hasn't yet gone to a right to view takings litigation. And I should mention the right to view is only recognized in a few states to begin with. So it wouldn't work in every state as a takings claim. That's one of the state specific property owner rights.
So thank you. Great question, Gabe. We have another question from Leslie Ewing. She says, the State Lands Commission has a lot of authority along the coast, especially in defining the public trust lands, and these often depend on tides. Some states are using tidal data that is shorter than the tidal epoch, which is about 18 years.
Right.
Do you see any opportunity for this approach to be used in the future?
I think it's going to have to as a practical matter. So the common law rule is that private property ends and public property begins at the mean high tide line. And the mean high tide line is judged by the average of the two highest tides over an 18.6 year cycle, which reflects the full lunar cycle of effects on the tide. That is an impossible line to find on any beach because it's not the vegetation line, it's not the detritus line from the last high tide. So it's kind of an ambiguous property boundary to begin with, but it's also ambulatory. And this is the law in pretty much every state, that private property boundary moves as the high tide line moves over that 18.6 year cycle. So if you're looking at sea level rise, you're already talking about an ambulatory boundary that's going to have to be judged if we're going to get serious about where that property line is on something less than 18.6 years, because the lunar cycle is not the only influence now on where that mean high tide line is. So yeah, I think we're going to see more and more jurisdictions figuring out some way to assess that moving line on a more regular basis, because there is a property owner on the other side, and it's usually the state. And if the state wants to be exercising, you mentioned the State Lands Commission. If the state wants to be exercising its authorities with respect to adaptation, among other things, it's got a right to that moving line. So yeah, long answer, but yes is the short version. We're going to have to.
Thank you. Thank you for that question, Leslie. I think we have time for about one more question, and there's one more in the chat from Dolan Eversole. They ask, are there any recent plans or examples of managed retreat in California using private property along the coast? Dolan's heard of a few big ones over the last 20 years or so, but nothing more recent. And if so, how are these funded?
Great questions, Dolan. I showed you the City of Ventura's plan. There's a little bit of retreat in there. I am not aware of any new ones in California. That doesn't mean they don't exist. It just means I can't find them. But there are other states who have been experimenting with this. Now, I will say other states often have an advantage in having land be behind the coast to retreat to. One of the problems you run into in California is as frontline property owners are becoming inundated, or it's becoming unsafe to be there because of storm surge, there's often no easy way to just back up a little bit, because there's a second line and a third line and a fourth line and a highway and a few other things along the coast. So the jurisdictions I know that have really gotten into retreat planning have some place for their frontline property owners to go because it's not completely developed. What to do in a completely developed situation. Florida's been dealing with some of those issues as in the truly dynamic island-based beaches that they have, where the front line of properties just disappears. And then comes back sometime later. They've had to deal with that issue, but that's not the same as managed retreat. So like I said, I'm not aware of any, and that's the physical problem that a lot of communities run into, is retreat where. So.
Yeah, and I see a follow-up question about state properties facilities, and I imagine that a lot of those challenges exist for that type of property as well.
Yeah, I mean, the government agency that I know of that is the most advanced in thinking about sea level rise and what to do and how to retreat is the Department of Defense. It's put a lot of energy into thinking about naval bases and strategic infrastructure and how to deal with coastal adaptation. But yeah, the issues are the same regardless of what level of government you are.
Awesome, thank you. So I know we're at the hour and people might have to jump off. I'll just say that we'll be sending out a follow-up email after this. And for those of you that can stick around, I'll just talk through some of those resources that we'll be sharing with you. But thank you so much, Dr. Robin Craig. This was really wonderful, and we're looking forward to being able to expand this work.
It's a good organization from.
Let me share my screen so I can just share how to keep in touch with us. So I think, oops, here we go. All right, so Andrew's just posted in the chat how to stay involved with AdaptLA. Again, I know for a lot of you, this was your first meeting, and we're really happy to have you, and we'd love to stay in touch. So an easy way to do that and to preview some of our past work and past projects and resources, you can go to our website. If you have any ideas for future meeting topics, we'd love to talk. We'd love to hear from you. So you can reach out to me directly, and I'm happy to brainstorm with you. And lastly, many of you here today are coastal practitioners. You work in this field of adapting the coastlines to climate change. And so you may have already received this link through another mailing list, but USC Sea Grant did just launch a survey, a statewide survey of coastal practitioners to better understand the needs and challenges of people that are working to build coastal resilience. So Andrew will drop a link in the chat for that as well, but we'll also include all of this, like I said, in our follow-up email. If there are any other questions for me, for USC Sea Grant, or for Dr. Robin Craig, please don't hesitate to reach out. We are hopeful and excited to keep these conversations going. So with that, I'll say thank you to the participants again for being here today. Thank you again so much, Dr. Robin Craig. And we look forward to keeping in touch in the future. Thank you.